I got a question for you. You spend a year designing your board game, the art, the mechanics, the box, the name. You finally launch on Kickstarter and it starts doing well. And then someone on the other side of the world copies the whole thing and starts selling it for half the price. What do you actually do about that? Here's the hard truth. If you didn't protect your game before you launched, the answer is usually not much. I'm Mark, and for the last 13 years, my team and I at LaunchBoom have helped over 1,000 founders raise more than $210 million through crowdfunding. And one of the most expensive mistakes I see creators make has nothing to do with their game design or their ad strategy. It's that they go public with their idea before they lock down the legal side, the trademark, the copyright, the contracts. And by the time they realize it matters, it's too late and it costs them a fortune to fix. Now, instead of me fumbling through this, I brought in someone who does this for a living. This is Zach Straybeck, and Zach is a California board game and video game lawyer, and he's worked with some of the biggest names in tabletop, companies like Stone Mayer Games, Restoration Games, and Duck Somnium. And he's gonna walk you through the 4 types of intellectual property, which ones actually matter for a board game, and a simple pre-launch checklist you can run before you ever hit publish. Now, quick disclaimer, I'm not a lawyer, so nothing in this video I say is legal advice, which is exactly why I brought in someone who is. So take this as your starting point and talk to someone like Zach about your specific situation. All right, Zach, take it away.
Why does it matter? Your intellectual property is your most valuable piece of property in your company, as far as I'm concerned, especially for game companies and any kind of sort of new media or new kind of product. While you have product inventory on the board game side and on the product side, the intellectual property that goes into creating that inventory is really the valuable asset here. So protecting that and locking that down, I think is a super important thing to do. And when you crowdfund, you're making your product public, which means that it's visible to people who are going to copy your product, or even those who don't want to copy it, but inadvertently may infringe on your product. So it's a good thing to be locking that IP down before you go public with your crowdfunding campaign. Couple scenarios here, right? You go live on Kickstarter, people start looking at your campaign. It looks to be up to the races, but there's people out there who are looking for products to knock off, things to copy, whether it's games or other products, and that can be where the trouble begins, right? People start to copy your stuff. Another scenario is that a competitor is using a name that's either the same as yours or very similar, without a registered trademark, or at least filing that application. You're going to have limited ways to go after them, especially if we're at a point before you've actually sold the product, due to how trademarks work. And we'll talk about that a little bit later. The fix is cheap, beforehand, but the problem can be quite expensive. So, spending hundreds of dollars now can prevent a lot of legal fees later on. Let's see how. Now, I have about 45 minutes of presentation to fit into 30 minutes of time here, so I may skip over things or kind of zip through things quickly. But I'll do my best here, and hopefully we pick it up in the Q&A if you have any things need clarification later on. So the big thing is the 4 types of intellectual property. This is when I went to law school. This is the first thing we learned about in IP class. These are the 4 main types of things that you can protect that are products of the mind, right? That's what intellectual property is. They're not tangible things. They're things that come from your mind, right? And so the first one is something called patents. These are extremely useful, but very expensive. And they give you a 20-year term of exclusivity. And they protect your useful invention. So if you've invented some new product or process or composition of matter, we'll talk about in a second, but you can get that protection. These are territorial, so if you get a U.S. patent, that doesn't necessarily help outside of the U.S. So again, the expense can be sort of international as well. So that's why most clients I work with don't seek patent protection, but we'll talk about that in a little bit. Copyright is another one. Copyright's going to protect your original creative works. There is a very long duration on these. I think it's 70 years after the life of the author, or 120 years for corporate owned copyrights. So that long duration, and then there's a very low cost. There's only a $65 filing fee to protect and get that registered, and it's one of my least expensive services that I provide. the utility of it is pretty high if you need to go after others for stealing your stuff. Trademarks are another one. That's another one that I do quite a bit. This is protecting your brand names and your logos. These last as long as you're actually using them, at least in the US. And you continue to pay the maintenance fees for the USPTO. But yeah, they can last. There are brands that have been going on for quite a long time, and they can keep going and keep those exclusive rights as long as they're actually using them in commerce, which is they're selling a product or service. And then trade secrets are the last one. We're not really going to talk about these today. These are basically trade secrets are your valuable secrets that you keep from the public that have some value in your line of or your industry, right? Think like the formula for Coca-Cola or the 11 herbs and spices for KFC, right? Those are the things they keep secret. There's no registration because if you were to register them, they would be public, right? And no longer secret. So you use NDAs when you share them with people, and you use data security measures to prevent them from being leaked. And that's really all you can do with the trade secrets. Next, let's talk a little bit more about patents. We look at what is the patent actually protecting. There's two main types of patents. There's something called utility patents that are protecting how your invention functions. This is the kind of common type of patent that you think about when you think about patents. Whether it's a piece of machinery or a piece of software, although that's less common now, or some sort of process. That's most commonly what people are name with a utility patent. On the other hand, you have something called a design patent that's going to protect the sort of ornamental appearance of your product, which actually can be pretty useful because a lot of times trademark isn't able to protect and copyright isn't able to protect certain things about the kind of look and feel of your product that a design patent could. Now, the design patent is going to be more expensive, but it may be the only way to get that protection that you need. Patents have a lot of very stringent requirements, which is why they're so difficult to get because there's a lot of back and forth with the examiners at the patent office. And because of that, you have to prove all of this, that it's novel, that it's actually a new invention, right? There's something called prior art where the examiners are looking for prior inventions and prior patents that sort of already are doing the thing that you're doing. It's sort of disproving that you have a brand new invention. To be non-obvious, which this would be to another practitioner of your art, not just anybody, right? I mean, it may be not obvious to a person walking down the street, but another person who's inventing or working in a similar industry as you, it may be obvious to them, and therefore it couldn't be patented. It has to be a useful invention, meaning it has to actually function and it actually has to have a practical purpose. And then it has to be in one of the categories that are patentable. So this machines, manufacturers, compositions of matters, that kind of thing. And then when you draft the patent, this is another reason why patents are so expensive to get. They have to be described sufficiently so that another practitioner could recreate your invention. So when you get a patent, you have to disclose it 100% exactly how it works. And that's why, when the patent expires, others can come in and use your invention. During that 20-year period where you have patent protection, you actually have the right to stop other people from using your patented invention. You don't actually get a right to use the invention yourself, which is a kind of odd thing about the patents. It's really an exclusionary thing, right? It gives you the right to stop people from doing something. Should you file a patent? Say you're crowdfunding a new product. It's worth exploring patents if you really do have a truly novel mechanism. Maybe in your board game, you have a new mechanic or something like that you feel might be worth patenting, or you have a new kind of invention, I really don't know, some sort of invention that you've come up with, and you're going to put this up on Kickstarter to crowdfund. Well, before you do that, it's worth exploring it if it really is truly novel. And if this is something that's central to your business's value, maybe you're looking for investor funding or crowdfunding. Investors like to see these patents, right? Because they know that there's going to be a period of exclusivity where you are the only one that can make this patented invention. And then, if a competitor were to copy your invention, it would destroy your market, right? It would really harm the business. So if any of those or most of them are true, I would talk to a patent attorney. Full disclosure, I don't do patents personally. You need to have a science background and pass the patent bar, be specially licensed to do it. I'm not. I can recommend someone if you need it. But yeah, definitely talk to a patent attorney sooner than later. Do a free consultation or even a paid consultation just to talk through it and see if there is something patentable there. Because there is a 1 year time limit. After you publicly disclose your invention, you have 1 year or else it is basically in the public domain. So yeah, even, and this is sharing it with really with anyone, any third party outside of an NDA or some other confidentiality relationship. So just be aware that you may be sort of giving up your rights if you wait too long or if you disclose too early. uh, Skipping patents, most of my clients don't bother patenting only because, their budget's tight or there really is no new invention there. It's just sort of something that it's the artwork or it's the trademark, the branding that's really going to be the thing that is valuable here, not the underlying invention itself. Again, I work with mostly game companies, so if it's video games and board games, most of them are just sort of they're not reinventing the wheel. You might say, they're coming up with new game mechanics that are sort of just innovations on existing ones or coming up with new artwork and theme and things like that. So nothing really patentable there. It's pretty uncommon for the type of clients I work with. But if the product also has kind of a short life cycle, right? You just have a few years, and that's as most games are like that. You're just going to sell this thing for a few years, typically before you are sorry, the police are driving down our street. Uh, if you only need it for a few years, then it's not worth going through the hassle of getting a patent. Because it's going to cost quite a bit. I mean, the utility patents for the full protection of the invention could go $10,000 or more and take 3 years to get if you get it at all. I mean, it's kind of unlikely still that you would get a patent only because it's such a rigorous process. There's something called a provisional patent application, which you can basically file now to avoid that 1 year time limit. It's sort of reserving your place to file another full patent within a year after you file the provisional one. Costs a lot less, though it's still quite expensive. But yeah, it's a way to sort of bridge the gap between, okay, well, we are going to disclose the invention now, but within a year, hopefully we're going to have the funding, maybe from investors or maybe from crowdfunding, we file that full patent. So one idea to do that. And then if you are looking for a design patent, they're going to be a lot cheaper. There's less office actions and sort of back and forth with the patent and trademark office. So they're going to cost a lot less. Again, it's sort of a cost benefit analysis you need to make, whether you think that's going to be worth it to others from using your invention or your design. Let's move on to trademarks, the other big one. And like I said, this is the big one that I do most in my practice. Trademark protects your brand names. These are, your company name or your game name or your product name, right? Xerox, Google, all these sort of, Apple is a good one, right? Any sort of word that is your brand identifier. Logo that goes with it and the sort of distinctive elements of your logo. And if you have slogans and taglines like just do it for Nike, and Nike has the swoosh as well, right? That's a visual design trademark that associates with Nike, right? And so that's an important trademark. All those things are what we call source identifiers, right? So when a consumer sees this in a store, right, they see the name of a game or a product, they know that it's coming from a particular company that makes that product, right? You see an iPod or an iPhone, it's coming from Apple, right? And so that connection allows you as the company that's making these products to kind of ensure that the quality is there and that the brand has goodwill, that the brand is, has consumers that want to keep coming back to you, right? If anyone could make these products using your trademark, then they would be of dubious quality and, it would tarnish your brand name, right? So trademark law gives you that exclusive right to both protect the consumers from getting poor quality goods and also to protect you from that competition coming in and sort of stealing the goodwill that you've built up with your customers. In the US, you get trademark rights by using the mark in commerce, which is to say you're actually selling the product or service that your trademark is connected with. Outside the US, I know we have a lot of people here from outside the US. Typically, it's going to be a first to file situation. So whoever files the trademark application first is the one that's going to have those rights. And we do have something like that in the US as well. But typically, you need to actually be using the trademark in commerce to get trademark rights in the US. And then registration is what we do, right? We file a trademark application and get it registered with the USPTO in the US. And it gives you tools to enforce your rights when someone is copying your brand, right? Or something confusingly similar to your brand. What makes a trademark strong? I think it's important to think about distinctiveness of your trademark, right? These top two here, arbitrary trademarks and fanciful trademarks, are the kind of most important and strongest types of trademarks you can have. So if you think about Apple, that's just a common word. So a lot of people think, well, I can't use common words. I can't protect them as trademarks, but that's not true. The reason you couldn't protect a common word like Apple is if you were selling apples under the brand name Apple, right? But since Apple is selling computers and music and all kinds of other things and phones, that disconnect between the brand name and the actual product underlying that brand name is what makes that trademark strong, right? So Delta or an airline, right? Anything like that. Xbox for games is probably more in the suggestive or fanciful type of thing, but PlayStation is another one that's sort of a suggestive, right? I'm thinking in the game context, right? But yeah, the sort of arbitrary words that are not connected with the underlying products are you're going to be your strongest types of trademarks. The other strongest trademarks are something called fanciful trademarks, which are completely made up words. So if you make up a new word for your product, you are the one using that, right? That is absolutely distinct for your brand. So something like Exxon or at some point escalator, I think, or Xerox, those kind of words are completely, I think there's an old video game called Zaxxon. That's like a totally new word that they made up to be that game's name. And because of that, they have dominion over that and they are the source of that name. So it's absolutely the strongest type of trademark you can have. A level below that are these suggestive trademarks where they kind of describe things, but they're more suggesting. There has to be like a creative leap in the mind of the consumer to go from the uh, the trademark or the product to the trademark or trademark to the product, right? So Netflix, is kind of like it's almost just describing, but you need like a little creative leap in your mind to think, oh, okay, well, it's flicks that are played on the internet or something, right? Warcraft is another one where, for a video game, you aren't necessarily going right from Warcraft to video games. You kind of have to make a creative leap there. And below that are these descriptive or generic trademarks, and these are unfortunately what a lot of clients bring to me. Right? These are trademarks names that are just sort of describing the product or a feature of the product, and that's what you want to avoid because that's not going to get you any kind of trademark rights, unfortunately. So you want to avoid them if possible. And so why I'm talking about this is because a lot of times before you launch your Kickstarter campaign, you are coming up with a new name for your product, right? And so you should be thinking about this trademark strength when you're naming your product. If you just name it something that sort of describes what the product is, that helps because, consumers then immediately know what they are, but it's also not distinctive at all because anyone should be able, they don't want to take these words out of the English language for people to describe these products. And so if, you have a name for your product that you can't protect and you can't stop others from using, it's kind of useless as far as a brand identifier goes. So you want to go up, the suggestive, the fanciful, the arbitrary trademarks when you're naming your trademark. And then clearance is the next sort of process we go through after we've decided on some names. And like I say down here, you want at least 3 to 5 names to start with, because with so many new trademarks being filed all the time and so many new products being made, most of, you think it's a good idea because someone else probably already thought it was a good idea, right? There's a lot of product names out there. So almost all the time, at least one or two, or maybe all of the names that are presented to me have been taken already. What we do when we do trademark clearance is we search the various trademark registries, some product specific search engines. Like for instance, for games, we're going to search Steam, itch.io and Board Game Geek, those kind of sites that are specific to games, just to see if there's existing usage or if on the USPTO site or sort of internationally, there's already registrations or applications for it, because you don't, you actually get some trademark rights, at least in the US, from using it, even if you're not registered, right? So you start selling a product with a name, we need to look for those unregistered trademark usages because they could have rights superior to our clients, right? And so we need to warn them, hey, there's this other product that's very similar to yours and has a similar name. They could come after you for trademark infringement. And we're trying to avoid that before we commit to a name and start paying for marketing for the name and, making logos and printing it on packaging and all that stuff. You want to clear it, make sure it's clear to use, and you're good to go. Why would you register a trademark? The big one for me, especially for crowdfunding, is there's usually a pretty long lead time between the time when you decide on the name and the time that you have products in hand and you're ready to sell them. And in that sort of dark period between I'm finalizing this name, I'm going to start advertising, I'm going to do crowdfunding and whatever, and actually I'm shipping product to the consumers. That dark period there is time where someone else could come in and start using the same name. And if they do, and they're actually selling a product, they now have priority over me, and I can't sell the product under that name, or else I risk them coming after me with cease and desist letters or trademark infringement lawsuits, et cetera. So you want to get that early priority date against others, which you do by filing a trademark application. We call it on an intent to use basis, right? We filing this now with an intent to use it later on. And because of that, you can reserve your date there. Like if we filed today, even if we don't finalize the trademark and start selling the product for another 3 years, our rights are going to date back to today. And that means that anyone in the meantime that started selling a similarly named product, we can go after them. Other benefits are, Amazon brand registry, if you want to kind of control your brand and stop counterfeits and things on Amazon. And a lot of other stores, a lot of the social media sites like TikTok and others. If you want to have a business account, you need to show a trademark, either application or registration, depending on the social media platform. Access to federal courts to file federal trademark infringement lawsuits are always good. And then you can register with the Customs and Border Patrol to potentially help stop counterfeit products from coming in. I think you need to alert them, and then they will look for it, and you provide them with all the information about your brand. And then if they see that stuff that's counterfeit, they should be able to help stop it. So when to do it? I'd say the earlier the better. You want to reserve those rights in your trademark before you start advertising, kind of finalizing the name, because you don't want to have to change it later on, right? And sort of redo your advertising and rebrand your stuff, right? When you've already built up awareness of your original brand. But be aware of the timing. In the US, at least, if you're not going to actually use it and have evidence that you're using it in commerce within maybe 3.5 or 4 years, I would consider waiting, because there's a limit to how long you can wait. And this is with all the extensions that they give you and paying the filing fees there. You have about 3.5 years. So if you're not going to make it in that time, I would consider waiting a little bit. But that's the kind of thing you would discuss with me or someone like me to see if it makes sense to wait. The last one we're going to talk about here is something called copyright. Copyright is protecting your original artwork, the written copy, in your rule books, game rule books, manuals, things like that, music and sound design in a product, the software, the source code, and things like that in software, videos, photographs, anything written down, any kind of creative work. We consider software code to be a creative work, a literary work here, books, things like that. All that stuff is protected by copyright. So what is not protected, it's important to know what's not protected when you kind of go into this. The ideas behind these things, the sort of concepts, game mechanics and like the underlying rules of a game are not protectable by copyright. Things that are tropes of a genre that are sort of used commonly, like a knight fighting a dragon, you can't protect that kind of thing with copyright because everyone's using it. It's not original creative expression. Things that are functional. So for instance, a lot of a car's design or clothing design, things like that are considered functional. So there's no protection for copyright, even though you may have come up with a whole new type of shirt cut or something like that. It doesn't matter. It's functional. So you won't be able to protect that. General information. So for instance, you are just, you put together a dictionary or something like that. Typically you can't protect that because that's just sort of general information that you've put together. You may be able to protect the sort of organization and selection of those words. Like if you create like a special dictionary for a specific subject or something like that, you may be able to get some protection there, but it's pretty thin and it's not really going to help too much. And then your names and your slogans and your logos and stuff like that, typically that's going to be protected by trademark, like we just talked about, as your brand identifier and not really by copyright. So this is another one. Why should you register copyright? I say here, you already have copyright. What that means is as soon as you create something that's copyrightable, right? You draw a picture on a piece of paper or you write a story on your computer and save the file. As soon as it's sort of a tangible thing, you have copyright rights in the US. So what's the point of registering, right? Without a registration, you can't actually sue anyone in the US in federal court. So your leverage to stop other people from copying your stuff is going to be limited. For instance, I have sent copyright cease and desist letters against people who are either copying our clients' work or doing something that's very similar, such that it would be infringement. And sometimes the first thing that the attorney on the other end asks is, well, where's your copyright registration? Because if I'm threatening to sue them, it's kind of a toothless threat if I don't have a copyright registration. Now, the good thing is you can actually expedite one and get it done basically overnight, but you have to pay an extra $800 filing fee for that. Otherwise, typically it's going to take 3 to 6 months for them to actually go through the process and look at your copyright application. So it's important to know that there is some lead time there. So if you want to be going after people, you need to file that application sooner than later. The registration also unlocks something called the statutory damages, and you can potentially get attorney's fees from the other side. So statutory damages basically is a amount of damages for copyright infringement that are written into the law, meaning you don't have to actually prove how much you've lost or how much you've been damaged, which is good because that can be very difficult to prove sometimes. A lot of the time, or it may be very low. So being able to get these sort of, especially when there's a willful infringement, they knew what they were doing, you can get tripled statutory damages. I think it's up to $150,000 per incident. But in order to get that, you have to register within 90 days of your publication of the copyrighted work, which is basically selling it or sort of sending it out to people, right? It's not just posting it on Instagram is not a publication. As crazy as that sounds, the meaning of publication for copyright actually is like you have to encourage other people to download it or actually be sending it out to people to be a publication. So for instance, you have a video game and you put it up on a game platform for sale, that's definitely a publication. But if you are just posting screenshots of it on your Facebook page, that would not be a publication of copyrighted work. Confusing, but that's why lawyers exist, to sort of deal with the plain meaning of words like publication and how they don't mean what you think they mean. And so, sort of to wrap up in general, I put together this pre-launch IP checklist. So if you are going to launch a crowdfunding campaign, there's a lot of things you should think about as far as your intellectual property goes. First, come up with a bunch of names for your trade or your potential product names and company names, and then run the trademark clearance search on your product name. A lot of times clients will do that first. They look on the USPTO's website and do a search, and they will search, Google and search, whatever game specific or product specific search engines there are. And that's good. I use like a third party service that is really, produces a lot of results, and I'll look through that, and I often will find things that they didn't see or that they didn't think were a problem, because then you don't have quite as much leeway as you thought you did. If you have an existing trademark that's a singular version and you do a plural version of that same word, that's not different enough. So if you just misspell it and it still sounds the same, that kind of thing, that's typically not enough. So, having someone who's seen a lot of these before definitely helps. So before you start printing things and running ads and designing logos and doing all that stuff, and especially before you go public with the name, I would run that trademark clearance and make sure that you are not infringing on any existing trademarks out there. And then number two, along with that, is get that intent to use trademark application in the US at least on file to kind of lock in your priority date before you run your campaign and you start advertising and doing things that could get someone copying your name. And then if you are planning to go international, for instance, you want to sell a lot in the EU, for example, you may want to file over there where they have that first to file jurisdiction where, you want to get something on file so that you lock down those rights as well. And number three is making sure you've got written agreements with every contractor, collaborator, anyone that's putting anything into your product or your, doing artwork, doing any kind of design work, designing your box, making trailers, anything like that. You want to have written agreements with all of them that sort of sign the rights to their work over to you. Or, if they refuse to assign their rights and they want to own it, a lot of artists maybe want to do that. Musicians are pretty notorious for wanting to retain ownership of their work and just license it to you. Just make sure that the license is broad enough that you're able to use it. So, no, I mean, I'm probably saying this a million times, but that's what a lawyer will help with, just to make sure that the contract is written in a way that gives you proper rights or broad enough rights as a license to the stuff that's going into your product so that you're not stopped from, using the logo you thought you paid for or, using the characters that someone created in a subsequent product or game. You want to make sure you're not limited artificially just because you didn't have the proper contracts in place. Registering your copyright within 90 days of launch, it says here. It's going to depend on how advanced your product is. You may not want to register copyright right away, only because the product isn't completed yet. So within 90 days of publication is when I would do it. I guess launch here is referring to the launch of the product, not of the crowdfunding campaign, unless you've got the product ready to go when you crowdfund it. And then, if you think there's any kind of novel mechanism or even a design look and feel to the product or anything like that, if there's any hint that there's something patentable there, I would talk to a patent attorney and just double check, right? You want to do this before you publicly disclose your invention, because otherwise you may end up losing those rights, and we definitely don't want to do that.
Huge thank you to Zach for that breakdown. If you got any value from this video, please give it a like and subscribe to the channel for more stuff like this. Oh, and one more thing, now that you know how to protect your game, you're probably wondering what all of this actually costs. The trademark, the copywriting, the printing, the whole launch. Well, we've got a full breakdown of exactly how much it costs to publish a board game on Kickstarter right on over here. So go ahead and click on it, and I'll see you on over there.